Hello everyone. This presentation is about law of obligation, which is a category of private law. What is an obligation? Obligation is a class of duties having a right in personam as its correlative. Now, what are rights and duties? Rights are what others are required to do for me, and duties are what I am required to do for others. Rights in rem are rights created by law and are available against the world at large, that is, against every other person in the world at large. Right in personam is a right created by parties by mutual agreement and are available against specific individuals who are party to the agreement. Duties in rem are duties imposed by law and are towards the world at large, whereas duties in personam are duties imposed by parties themselves and are towards specific individuals. Rights have duties as correlatives. Obligation is a duty in personam which has a right in personam as its correlative. It is a legal bond of necessity called vinculum juris and it binds together two specific individuals. It may be in the form of payment of debt, performance of a contract, or payment of damages for tort. But it does not include a duty not to interfere with person, property, or reputation of others. Why? Because in the case of payment of debt or performance of a contract, it is an agreement between the parties and the duty here is created by the parties. Whereas in the latter case, that is duty not to interfere with person, property, etc., the duty is imposed by law. Similarly, where the rights are rights relating to the status of a person like marriage, adoption, etc., they are not obligations but duties imposed by law on the person concerned. Thus, obligations pertaining to proprietary rights, that is, rights pertaining to property and not to personal rights, though they are rights in personam. Obligatory rights are therefore proprietary rights in personam. Rights over immaterial property such as patents, copyright, trademarks, they do not create obligations. Obligations can be classified under four heads. Contractual obligations, that is obligations created by contract. Delictal obligations, that is obligations arising due to commission of tort. Quasi-contractual obligation, that is obligation arising out of unjust enrichment. Though they are not in fact contractual, they are contracts in law, considered as contracts in law. And innominate obligations, that is obligation of trustees towards beneficiaries. Law of contract provides the necessary principles governing contractual obligations and quasi-contractual obligations. Now, what is a contract? It is an agreement that creates or intends to create a right in personam between contracting parties. Are all agreements contracts? Though all contracts are agreements, all agreements are not contracts. An agreement would become a contract only when a legal bond of necessity is created which binds the parties to the agreement. Generally, a contract is a promise or a set of promises, but every promise will not create a contract. Promise to do an act does not amount to a contract unless there is a duty created to do the act. For example, accepting dinner invitation is a promise but not a contract because the parties do not intend to create any legal relation between themselves. Essential form of contract is not I promise this to you, but it is I agree with you that hereafter you have a legal right to demand and receive this from me. Intention of the parties to create legal relations between them is the most important element of the contract. Aquinas said that human will by way of consent makes a thing just, but the thing consented to should not be against natural justice. Thus, an agreement will not be a contract if it is vitiated by incapacity, informality, illegality, error or mistake, coercion, and want of consideration. Quasi-contractual obligations include all pecuniary obligations that are made for compensating the loss suffered. Payment of debt, satisfying a judgment, refunding the money received by mistake, fraud, or duress are quasi-contractual obligations. Where a party enriches himself unjustly due to the mistake of the other party or due to the fraud played by one party upon the other, there is an obligation on the party so unjustly enriched to compensate the party suffering the loss. Quasi-contracts also include cases in which a person injured by tort is allowed to waive the tort and sue in contract. For example, when money is obtained by fraudulent misrepresentation, the affected party may sue in tort for damages for deceit or in quasi-contract for return of money. Delictal obligation, which is a duty of making pecuniary satisfaction for tort, is dealt with under another branch of law, that is law of torts, under the head remedies for torts. Innominate obligations include obligations of trustees towards their beneficiaries. Rules governing various kinds of trusts are dealt with in law of property. So far as contracts are concerned, they can be general contracts or special contracts. Sections 1 to 72 of the Indian Contract Act deals with principles governing general contracts and quasi-contracts. Principles governing some special contracts like contracts of indemnity, guarantee, bailment, pledge, agency, etc. are provided under sections 124 to 238 of the Indian Contract Act. In addition, special laws like the Sale of Goods Act, the Indian Partnership Act and Negotiable Instruments Act contain principles governing certain types of special contract. Every one of us enters into a number of agreements, express as well as implied in our day-to-day life, be it as a consumer of various goods and services or as an employer, employee, contractor, businessman, etc. And a broad idea of certain basic concepts of contract law becomes a must as a lawman as well as a common man. Thank you.